This is a seminal case that explains the law on the interconnected issues of marriage, children, estates, and everything in between. Thorny real-life issues that are fodder for many radio and TV shows in Ghana. These are stories that happen every single day. William Bart Plange was a prominent contractor in Ghana who died in March 1987 after a terminal illness. Like many wealthy men in Ghana, his personal life was complex. He left behind 7 children, 4 with one woman named QUAYNOR and 3 others with different women. This man decided to write a will that basically sidelined Beatrice and her children completely. He gave 2 houses to his favorite daughter Agnes, one in Nsawam and another in Koklomlemle. He gave another house in Accra, Newtown, to his daughter Janet, even adding a clause that she could kick out anyone who misbehaved in the said house, especially her brother, who he described as someone who drinks like a fish. But Beatrice and her 4 children had nothing, not a single cedi. The only time he mentioned Beatrice in the entire will was to call her his ex-wife and say he didn't want any quarrels between her and his children. Beatrice was understandably very aggrieved. The facts were that she had shared a bed with this man, born 7 children with this man, 3 of whom had died. Of the 4 that remained, 1 child was mentally disabled and crippled from birth, and another was still a student. Being a pensioner with no income, how was she to shoulder these burdens? She took his other daughters, who had obtained probate, to court using Section 13 of Ghana's Wills Act, which basically says that if a person dies and he didn't provide reasonably for their parents, spouse, or young children under 18, a court can step in and fix it. Even in the grave, you cannot abandon your responsibilities to those who depended on you in life. She also challenged the device of the new townhouse to Janet because she was also an attesting witness to the will. Generally speaking, attesting witnesses cannot benefit from a will, and any devices to them thereunder are void. The beloved daughters of Mr. Bart Plange fought back hard, claimed Beatrice was never actually married to their father, just living with him. And even if she was married, they had been separated for almost 10 years, so the marriage was dead anyway. They also argued that her children were all over 18, so legally speaking, they could not claim anything under Section 13 of Ghana's Wills Act. The evidence showed, however, that Beatrice and William had a customary marriage way back in 1950. Yes, they had physically separated, but the story was a bit more complicated than that. Initially, William asked her to go and stay with her mother for some time. This was a mutual decision, but then he abandoned her for 8 years. He came back, however, and had more children with her. When she tried to return to the family home later, he refused to let her back in. The courts had to decide, was this still a marriage or not? A pattern of oscillation in and out of cohabitation had been established, so the courts held that it was reasonable for Beatrice to expect that things may be patched up in the future. Also, there was no formal dissolution made, nor did Beatrice remarry or stay with any other man. Key evidence was submitted to the effect that William's own family allowed Beatrice to perform widowhood rites at his funeral. In Ghanaian culture, only a wife gets to do that. The High Court ruled that yes, Beatrice was still his wife despite living separately, so she was fully entitled to a reasonable share. They ordered that the rent from the house given to Agnes in Kokomlemle should go to supporting Beatrice and her disabled child for the rest of their lives. They also threw out Janet's inheritance because she had witnessed the will, and legally, witnesses cannot benefit from wills they attest to. But the story doesn't end there. Agnes and Janet, also aggrieved, appealed to the Court of Appeal. The Court of Appeal agreed on some points but changed and modified some of the orders the High Court gave. They confirmed that Beatrice was indeed the wife, but there was a cruel twist. Her children could not get anything because they were all over 18. The law protects only children under 18, and even though one was mentally disabled and completely dependent, he was over 18. The law is the law. The Court of Appeal said if Beatrice was getting something, it should come from whatever was left after specific gifts, not from Agnes's houses directly. It was unjust and unreasonable for the High Court to sidestep leftovers and target some one specific gift under the will. But herein lies the beautiful irony. Remember, Janet lost her house because she witnessed the will? Well, that house now became part of the leftover estate, what we call the residuary. And William had forgotten to say what will happen to leftovers in his will. Under Ghanaian law, when there is no instruction about residuary items, they get distributed according to P&DC Law 111. So Beatrice and her children, who were completely cut out of the will, suddenly had legal rights to a share of the estate anyway, particularly Janet's house. The man who tried to exclude them ended up providing for them through his own legal mistake. The case teaches us some serious lessons. If you want to end a marriage permanently, a formal divorce is best. Don't just physically separate, or your spouse might have claims to your property that you may have never intended. Wills may be drafted by anyone as they are not legal documents under Ghanaian law. However, the law is full of technical traps, so a lawyer's involvement is key. The case is a reminder that no matter how carefully inequity and unfairness is planned, fate, law, and life has its way of protecting the vulnerable. Justice always finds a way. Follow Super Law GH Studios for more real stories, real cases, real people.